You know, righting the historical wrongs of the past while trying to build a functional future is absolutely one of the most complex challenges a nation can face. Today, we're diving straight into the heart of South Africa's land restitution process in this explainer. We're going to unpack a really fascinating, highly charged legal battle, Constitutional Court Case CCT 29/06. This isn't just about property, folks. It's about how the law actually balances the deep scars of history with the messy practicalities of modern development. Imagine for a second that the government took your land through racist, discriminatory laws. Does the Constitution guarantee that you get that exact piece of undeveloped land back decades later? On the surface, it sounds like a simple yes, right? But as you'll see, the reality of actually implementing that justice is incredibly complicated.
Here's a quick look at our roadmap for this explainer. We'll touch on the promise of restitution, the framework agreement, how a community divided, interpreting the Constitution, and finally, the court's verdict. Let's jump right in.
Part 1. The promise of restitution. We really have to start by winding the clock back. The painful history of dispossession began in earnest for many communities after June 19, 1913, under some heavily racially discriminatory laws. For nearly 80 years, people were systematically stripped of their property. But then, transition and hope finally arrived. In 1994, the Restitution of Land Rights Act was passed specifically to heal these very wounds. And that brings us to the year 2000, when a totally crucial framework agreement was signed in Port Elizabeth to restore land rights to those dispossessed in the Fairview and Salisbury Park areas. Moving on to Part 2, the framework agreement. So how do you actually go about giving land back to an entire community? Well, instead of everyone demanding their original vacant plots back, a community organization called PELCRA and the government agreed to a collective strategy. They decided to pool their resources. The claimants would receive compensation averaging 30,000 rand, or they'd get a smaller, fully serviced residential plot with an actual dwelling right alongside brand new commercial facilities. And the scale of this turnaround was just massive. To put it into perspective, we're talking 41.92 million rand, heavily funded by the National Treasury. It was a really pragmatic approach, taking vacant, undeveloped land with nothing but dirt roads and transforming it into a modern, fully serviced township. The claimant signed off on it, and the bulldozers got to work. Part 3. A community divided. But here's where things take a bit of a turn. In July 2001, when the actual layout plan was displayed, a massive rift formed. A breakaway group of claimants looked at the plans for this high-density housing and realized their new residential stands were going to be a lot smaller than their original land. They decided, no way, they didn't want the new township. They wanted their original, sprawling, undeveloped plots back. Meanwhile, PELCRA and the government were pushing full steam ahead with the collective development, which in legal terms is known as equitable redress. Well, this disagreement sparked an absolute marathon of a legal battle. By August 2001, the breakaway claimants had organized themselves. Jump to 2003, they hit the Land Claims Court to halt the development entirely, but they were dismissed. In 2005, the Supreme Court of Appeal dismissed them yet again, but they refused to concede. They pushed this all the way to the highest court in the land, the Constitutional Court, in 2006. Part 4. Interpreting the Constitution. How on earth does the highest court resolve a clash between a community's collective progress and an individual's desire for their original property? Amazingly, it all hinges on a single, tiny word in Section 25, subsection 7 of the Constitution. It states, a dispossessed person is entitled either to restitution of that property or to equitable redress. That little word, or, is doing an incredible amount of heavy lifting here. So what does equitable redress actually mean in practice? Essentially, it's an alternative. Under Section 40D of the Act, the minister has vast discretion. They can award land, they can pay cash, or they can do a mix of both. In this specific case, the minister legally approved that collective township deal as a perfectly valid alternative form of justice. Finally, Part 5, the court's final verdict. Okay, let's get to the climax. The Constitutional Court ended up dismissing the breakaway group's application for 3 really fascinating reasons. First off, they ruled there is no absolute right to demand your exact original land back. I mean, let's face it, after 80 years, literal restitution is sometimes just impossible. Second, the applicants dragged their feet. By the time they reached the top court, the land was already becoming a fully serviced township, and overturning that would severely harm the majority who had already moved on. And finally, the folks who opted out weren't left completely empty-handed.
they could still pursue individual financial compensation outside of the specific deal.
So, the application was dismissed. But there's a really interesting footnote to this ruling. Normally, the loser pays the winner's legal costs. Here, the court ordered each party to just carry their own. They impartially recognized that these applicants weren't just filing a frivolous lawsuit to be difficult, they were genuinely trying to enforce their constitutional rights. It was a deeply human pursuit of justice, even if it didn't pan out the way they wanted.
Which leaves us with a pretty profound question to chew on as we wrap up this explainer. How do we actually balance an individual's rightful historical claim with the pragmatic, everyday needs of a modern, developing community? This case proves that while the law absolutely aims for justice, true justice sometimes requires compromise, looking forward to community progress just as much as we look back to correct the wrongs of the past. So what do you think is the right balance?